How do you respond to a USPTO Trademark Office action? Imagine opening your mailbox and finding a letter from the United States Patent and Trademark Office. It's not a rejection, but an official notice called an office action. This can feel intimidating, but it's actually a normal part of the trademark registration process. When you file a USPTO application for a trademark, the examining attorney reviews it carefully. They might find issues that need fixing before your mark can be registered. Responding correctly can keep your application moving forward. So, what's the best way to handle this? Let's walk through it step by step. First, you need to understand what the office action says. It's an official letter that lists problems with your application. These issues can be minor, like a typo or missing information, or more serious, like a legal refusal based on trademark law. Carefully read every part of the letter. Make sure you understand each objection or refusal. Sometimes, the examining attorney will ask for clarifications or additional evidence. Other times, they might refuse registration because your mark conflicts with someone else's. Knowing exactly what they are concerned about is key to crafting a good response. Next, pay attention to the deadline. You generally have 3 months from the date the office action was issued to respond. If you need more time, you can request a 3-month extension for a fee. This can give you up to 6 months to reply. For international applications under the Madrid Protocol, the deadline is 6 months, and no extensions are allowed. Missing the deadline means your application will be abandoned, and you will lose your filing fee. So, it's important to stay on top of the timeline. Now prepare your response. This is where you address each issue raised by the examining attorney. If there's a procedural error, like an incorrect description of goods or services, correct it. If the refusal is based on a legal issue, you can argue your case by citing relevant laws or USPTO rules. Sometimes, submitting additional evidence or specimens can help prove your mark is in use and distinctive. If necessary, you can amend your application to overcome the objections. Be clear, concise, and thorough in your reply. Most responses are submitted electronically through the USPTO's Trademark Electronic Application System, or TEAS. The system offers specific response forms depending on whether the office action is final or non-final. For minor issues, a simple response form may suffice. For more complex legal objections, you might want to consult a trademark attorney. They can help you craft a response that is legally sound and more likely to succeed. After you submit your response, the examining attorney will review it. If your reply resolves all issues, your application will move forward toward registration. If not, you might receive a final office action. At that point, you can file a request for reconsideration or appeal the decision to the Trademark Trial and Appeal Board. This process can be more involved, so professional legal help is often beneficial. Responding to a USPTO office action might seem daunting, but it's an opportunity to clarify and strengthen your application. Timely, well-prepared responses that directly address the issues raised are your best chance to keep your trademark registration on track. Remember, staying organized, understanding the objections, and seeking help if needed can make this process smoother and more successful.